Hey everybody, welcome to American Courts tonight. We got a whole pile of people in here. Let's see. Got Emily, Nan. Hey Nan, got Nancy Myers. How are you doing tonight, Nancy? Sivo girls here, Lena's. Um, Looks like we're ready to get started. We got some Judge Middleton and some Thurston County tonight, at 9 o'clock. Jen Hardy's got another show tonight, and so the title of tonight is Sparks Fly Oakley has a soft set. Heck yes, 10 p.m. 10 p.m. Central. This is how you call first, by the way. Absolutely, roll on G. Roll on G is first in there. How about that? We're gonna jump into some judge. Let's do Sam Myers, judge over in Thurston County. He's got a fun little one. It's not too long. It's only about 10 minutes long. So here we go with that one.
So then it was filed in July, and there was a case filed in July. Nobody showed up. He filed again in September. And now here we are. So when I say no order was entered, you can enter what's known as a temporary order. And if that, then again, you've heard me talk about this earlier today. I hear testimony, and then I decide whether or not the temporary order gets extended for a year. There's not a temporary order in this case. No. And so, no, there was never a temporary. So just going to read a definition of harassment. Unlawful harassment is a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, harasses, or is detrimental to such person and serves no legitimate or lawful purpose. Course of conduct must be such as would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress to the petitioner. And then a course of conduct is a pattern of conduct composed of a series of acts over a period of time, however short, evidencing continuity of purpose. So what happens on these cases, I'll swear you in, I'll hear from you. I'll swear in Mr. Wagner, I'll hear from him. I think I got a good sense of your position based on your petition. I did review, there's always two sides to every story. I heard Mr. Wagner, I saw Mr. Wagner's response. So, again, I'm going to start by saying not every conflict is harassment. Sometimes people have conflict, they don't always get along, but it doesn't rise to the level of harassment. They're just, sometimes people who don't like each other and probably shouldn't be apart. Looks like at some point you folks got along. Like according to Mr. Wagner's response, you hired him to do some work. That kind of went south over the leaf blower incident, as far as I can tell. I saw
No, it went south over the work.
Okay. Well, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Go ahead. How is it you need an order against Mr. Wagner?
He, after the work was done, he pulled off the job once. And then I said, he came back and sincerely apologized for doing that. And then
Doing what?
stopping the work
Oh,
before he was finished. And then I said, okay, this is it. You're welcome to come back. You've left me high and dry, but come on back, finish it up, and that'll be it. I'll pay you what I owe you. And he came back for maybe an hour or two and just messed up his work that he had messed up the work. So he then left in a tizzy. And I was left with the work. So I'm putting away all the stuff. I just began putting away all the stuff. And then I was all finished for the day. And I wanted to blow out my carport just to get it clean. and had to pick up a lot of trash and whatnot. I had it all done. I wanted to blow it out. I couldn't find my blower. And I knew it had been there, and he was the only one in there. So I went over to his mother and I said, aside from him walking off the job and leaving all this stuff for me to do, aside from that, and attempting to steal money from me, I believe he stole my blower. He stole my blower, and I want it back. And this was in the morning. I said, I want my blower back. And she said, well, I'll get a hold of him. I said, well, I'm telling you that you have until 12, and he has until 12 to get it back to me. I knew he was handed to me, right there or whatever. And I said, get it. I want it back. Well, he didn't get it back. It got to be 2 or so in the afternoon, something like that. And I called the police and made a report, and they wouldn't come out. They wouldn't come out. And after that, he sent me texts. Why are you bothering my mother? He was very upset about that.
Well, he didn't take the blower, did he?
So no. So I looked and I looked and I looked for the blower. So that evening, that night, I found it on a lower shelf. So I sent him a deep apology. I mean, I was sincerely sorry that he did that, or that I didn't continue to look more, but I was just so sorry. So I slept on it, and the next morning I wrote a sincere apology. And
he included that in his exhibits.
Well, he included that I did. I don't think he did. He had those 2 pages of my apology and them accepting it. And so it was all over, kind of. And so I had mixed emotions about, but he had, in his text to me, he had said, you better not bother my mother, and you best be able to sleep you're the one that has to sleep with one eye open. I took that as a threat. I took it as a threat, and that's before I apologized about the blower, and they accepted my apology. Him and his mother, I texted each of them.
So, and this happened a couple of months ago,
So
right?
that was, the end of July, after he walked off the job. And anyway, so then I cleaned up. She was very, nice to me, like she had always been. And I was playing cards with her and the women there and stuff, and all was well. But he was just cold, and I would say hello or whatever. But so it was very uncomfortable. It was just uncomfortable, which is fine. I didn't file anything at that point. I was just going to let bygones be bygones and deal with him being there and parking every day behind my vehicles right there in the spot where he could have parked behind somebody else's house. His mother has a spot for him to park in, a pad. Anyway, so one day, a couple days before I filed this report, I saw him parking right there, right behind me. And I said, could you please find another place to park?
Does it block you?
Yeah, it blocks me, but there is
okay, so I'll give you a chance, Mr. Wagner.
There is an alleyway, a one-way alleyway. So it's wide enough, 10 feet, 12 feet of an alleyway behind me and between where he parks. He might have given me a couple, 3 feet of space in this green belt area. And, but, I couldn't pull out. I would have to do, 3-point turns and stuff. And it was just very inconvenient. Plus, we had words, and we weren't, it wasn't a friendly situation. And he had attempted to rip me off during his work time with me. I just couldn't trust him anymore. And plus, he told me to keep one eye open. When I went to sleep, I still felt a threat. Anyway, so I didn't go back to court then. Then I was in my garage and I saw him parking there and I said, and he got out of the car, I said, could you please park somewhere else? You're blocking me. And he's not, I've experienced another issue with him, that he's not one to be told where to walk or where to park. You know, I experienced this outside of the complex with him, with a gentleman, a dude, a guy from that owned a park near us that we happened to be walking through, and he asked us not to walk through there. That was a different issue. It was horrible. It was horrible. So I saw what he was capable of at that time. He got right up in this guy's face, right up into his nose, and the guy was even taller than him.
So I'm not,
All right,
I don't.
But all right, so forget that instance. But I was fearful of this guy. I felt he was dangerous, you know, because he told me to sleep with one eye open. So when he got riled up about me asking him to park somewhere else, he just about immediately texted me that he seen smoke come from my bedroom. That's when I called the police.
Okay, what? Let me hear from Mr. Wagner. Mr. Wagner, could you raise your right hand? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
What's your response to the request from Mr. Stein?
I think it's unnecessary, you know, and unfounded. He's just making accusations that are not true. I helped him out a lot. It was not just one job, it was like 3 or 4. I helped move his house. I was very nice to him all the time. And this parking lot situation, his house is there by the parking lot, but it's not his property. It's overflow parking. I'm allowed to park there. It's just a bunch of unfounded accusations that he's claiming, and I just feel it's a waste of the court's time to even go any farther with it.
What's the significance of the smoke coming out my window? I don't understand that.
I don't either. I didn't do that.
Yeah, let me hear from Mr. Stein.
He told me at one point, not a month before that I needed to sleep with hope, you know.
I know you said that,
He
but then
said he texted it. I have it.
I know that.
Okay.
My question is, you said smoke coming out of the window. What?
No, he didn't say the window. He
Okay.
said he sees smoke coming up from my bedroom, like through the roof.
Okay.
I went out and had to look around. I
Okay,
looked in
so
my closet.
hang on just a minute. Mr. Wagner, what's the smoke issue? I'm confused by that.
I'm confused too, Your Honor. I didn't say anything like that.
Well, I have the text.
Do you have it? I mean,
Yeah.
what does it say? Did you submit it in your petition?
I did.
Okay, it's attached to the petition.
What's that?
It's attached to the petition, the text
No,
itself.
I had it attached after I left here.
Okay,
After I left.
okay, all right, hang on just a second.
Had it.
What does it say?
It says, I see smoke coming from your bedroom.
That's in a text?
Right here.
Can I see it?
It's not his normal.
Okay, you go ahead and take a seat.
Does it show my phone number, Your Honor?
No, it doesn't.
Up on top.
Well, yeah, it does. It says, but you said that's not,
I don't believe, I think it was a burner phone that he had.
okay, so this wasn't from his phone. You don't know where that came
It
from.
came from him.
Okay, well, you think it came from
It came
him.
from him right after the incident with him
All right.
having.
I'm gonna go ahead and give this back to you.
I have a text.
How you getting along with his mother these days?
She's not very happy.
I don't suspect so. Well, Mr. Wagner, what say you with regard to the smoke?
I have no idea what he's talking about. I never sent him a text saying that.
Saw a text. I said, I have to may I say something else?
Yes, you can.
So I have the full texting of the other incident where he said he'll mess me up. Right here.
Give that to me. Okay, you go ahead and take a seat. Was this before the,
This is the July,
yeah, but
why I called, or why I
Right.
called the police first. the
this
first
was
time.
before the apology, right?
This was, no, yeah, this was just, I mean, like, minutes, an hour. It was that same day.
But it was before
at-
before you apologized.
Yeah, I hadn't found the blower,
Right.
but I did.
Okay, so
accuse
hang on
him
just a
of
second.
that. Yeah.
All right, give me just a second. So this parking place. And so Ms. Wren, I see you there. I'm just gonna have you mute up. We'll take your case next. I mean, is that,
I don't know how to do this. Okay, thank
well, then
you.
just be quiet, please. There you go, okay. Okay. So, so the one eye open, mess you up, that all happened. I have this context. I'm gonna read all this. Then the apology happened. And then things were tense until this parking situation, but the whole mess me up thing happened before that, right? Okay, and so this parking situation, I mean, is that a legitimate parking space or is that,
It is for visitors.
okay, when he's a
and
visitor,
for
isn't
no
he?
more than 1 or 2 days, I've been told by the management.
All right,
That's what I was told when I moved in April. Well, I bought it in April. And so I've been working on it, and that's what I assumed. It was I could walk my dog out there. It was green grass. It wasn't for people to stay very long. That's what I was told by the property manager when I checked out the property to purchase it. And she said it's for for 1 or 2 days, for guests, for guests of people, if they were having a party that, at their house and they wasn't enough parking, they could go, there's enough room for probably 20 cars back there, 15, 20 cars. And he would choose to park right behind me all the time, ever since the first incident.
all right.
And then I didn't tell you one thing. After the police left this last time, 4 or 5 police were there.
For
After
the
they
last time, what
left,
happened? Why did you call the police this last time?
because he told me about the smoke coming out of my bedroom. He saw smoke, and I've been told by my neighbor very close, who's 90 years old. I cannot get my I've been told by them that he's a dangerous guy and he's threatened to burn their house down. And I'm like, come on.
Okay, so,
That's just hearsay, I know,
right,
but he
So
just
here-
said it to me.
here's what's gonna happen today here, Mr. Stein and Mr. Wagner. First of all, again, there was a petition filed in July. Then nobody appeared at that, and so it was dismissed. And so this petition was refiled. And as far as I can tell, the issue is the sleep with one eye open incident, the mess you up comment combined, and then this vague and this smoke coming out of your window. And so again, this text chain I think is kind of interesting in that, and again, first of all, Mr. Stein says, you better chill out. I didn't take anything of yours. That was Mr. Wagner. Mr. Stein responds by saying, BS. You were the last person to use it. You have until 12 p.m. to produce it. And then Mr. Wagner says, but if you want to start something, then let's do this. But you're the one who will have to sleep with one eye open. And then you, Mr. I want to get the names right. Wagner says, you were the last one to use it. It was by your sliding glass door. Next text, and stop involving my mom in this. And if you stress her out, I'll mess you up. So the mess you up is kind of conditional. It's like, leave my mom alone.
Exactly.
And then he says, why are you going to call the cops? I didn't take your blower. You're upsetting my mom. Chill out. Why are you saying all this stuff to my mom? That's all from Mr. Wagner. Your response, where did you put the blower mark? It was by your sliding door. You put it away. I never used it. And then he goes, you owe me more than $50. You say, that's crap. You're a desperate person. I don't see the rest of that. And so that happened back in July, pre-apology. And so I'm going to give this back to you. And so as far as I can tell, the apology happened. Things remain tense, which is kind of understandable. And now there's the issue of the smoke, which I can't even make a finding that I know you think it came from Mr. Wagner. It's from an unknown number. But you know, from where I sit, I kind of need more than that. I can't make a finding that that came from Mr. Wagner. And if he's parking in a legitimate parking spot, there's, you know, he can do that. And so, so that's a long way. And again, as I said before, I don't find that the behavior that's been attributed to either party rises to the level of harassment. And so I'm not going to enter an order at this time.
The last time you did enter, not the last time, but you entered an order, and the only evidence I had at that time was that he told me to sleep with, not the only evidence, but you know, I had it in writing in the text that I hope you can sleep with one eye open. You're the one that will have to sleep with one eye open. And I have been sleeping with one eye open ever since.
Okay,
I
so
was never
here's
sure
the thing.
within.
Okay, so Mr. Wagner, just stop. Okay, so here's the thing. Okay, first of all, that was a temporary order in July.
Yes.
And you know, and I didn't say this to you, but I say it frequently, you know, there's always two sides to every story.
Right.
And when you enter the temporary order, you're only getting one side. And so that was in front of me in July. I did enter a temporary order. When this came before a different judge, they didn't enter one. And you know, maybe I err on the side of caution, which I typically do when you're only hearing one side of the story. And then that's why they set it for hearing, so you can hear both sides. Having heard both sides now from him and from you, I'm not going to enter an order at this time. Having said that, Mr. Wagner, I think you kind of know how because again, well, let me back up here, Lynn. Not all conflict is, and yes, there was when he said that was pre-apology. The apology went, and then then the only thing since then is the smoke text, which I can't make a finding who said that, and the inconvenient place where he chooses to park. And so that's not a pattern of conduct that rises to the level of harassment. And that's my finding here today.
Can I show you one picture that I hadn't showed you, what he did after the police left? I started to tell you, but
okay. So maybe you should just give that phone to your friend back there.
Okay.
So hang on just a minute, Mr. Wagner. What's the picture?
He moved his, first of all, he took his license plates off of his car, but he moved his car from where it was parked behind me in that area. When the police were there, he moved it and parked this close to, well, this close, because I got my hips through there. Okay, this close to me. So I couldn't get in the car. And I had to go to work that day. I was able to squeeze.
Okay, Mr. Wagner, you need to be quiet. Okay.
And I have the picture of the car parked that close to me. It was that day of the police being there. Now, he was really harassing me at that time. He had a whole nother lot, and I have that picture, and I have it. I just had to get it out of here. And at the time that I filed, I didn't, You know, the picture was on my phone. I didn't have it. I'm not used to going to court, not at all. It's right in here. I'm not used to having someone that, you know, scare me ever in my life like that, ever.
Well, you know, I'm not suggesting that that series of texts was appropriate, but you know, people don't like it when they get accused of theft either.
I
Exactly.
apologize.
I know you did, and
He has not apologized
Okay.
for making those threats to
okay,
me.
so okay, but
He
I'm
hasn't
just
at
saying,
all.
Mr. Stein, you need to, yeah, I hear you, but you need to
What?
just collect yourself here.
I've been
Okay.
really stressed
Okay.
for 2 months now, really bad.
Okay,
It's really bad.
okay. So that's what I'm going to do here for today. And so, and I'm going to tell you, I'll tell Mr. Stein, Mr. Wagner, you know, Mr. Wagner, you have some choices to make too, as to where you know, where you want to park, and you kind of want to think about how, okay, is this thing going to make things better, or are these going to make things worse? And so
I was
you can
told-
conduct yourself accordingly. So hang on, let me finish.
Right.
And Mr. Stein, I'll tell you, if he does, and again, parking in a place
You don't
that he's
believe
illegally allowed to park to, again, I just don't,
it, sir.
again, I just can't make a finding that's harassing. If he does additional stuff that you believe is harassing, you can refile this, but it needs to be subsequent stuff to stuff that's already gone on.
He's
And so
threatened I mean, pretty much, he's threatened physical and physical harm to my property, myself, anybody in the house.
Okay.
And
Based
and
on-
I can't, I mean, and I'm not allowed to call the police.
Well, you are allowed to call.
Now, they say it's a civil issue.
What's that?
Another thing is the
Okay.
park is kicking him out.
Well, then then
That's really nice. I
that could
like
solve your
that.
problem.
That could, but it doesn't give me a protective order from him
All right.
harassing me.
That's it for today.
All right.
And you're free to go.
Hey everybody, thank you for showing up. We got a little bit more of a crowd. Vicky, Carla, Susu, Bodie, and Steve Bennett. This morning Steve told me about Judge Oakley one. We're gonna do that one. It'll probably be around 9 o'clock, so we're gonna give about 30 or 40 minutes before we get to that one. I just talked to Jen. She's not gonna be doing her live tonight, so I'm gonna keep going till about at least 10 or 10:30. So if you can hang out, hang out. If you can't hang out, I appreciate you stopping by. Looking at the comments real quick, we have great people in the comments section. I really appreciate all the comments that are going on. During the day, Judge Fleischer's courtroom has a quite a lively comment section too. And just a reminder to people, you know, what's appropriate in the court. Say it. Think about if the judge were to see it. Think about if the newspapers were to see it. Think about if other people were to see it, the defendants in the court. So be thoughtful on your comments there. Here, you know, it can be blamed on me, and I don't mind getting the blame for it. I'm a creator, and I'll take responsibility for anything that happens on my channel. But let's not put the court or put the judge in an odd spot on his channel. So just be thoughtful about your comments. Be thoughtful about the things that you say over there. You know, here almost anything goes, as long as you're not being hateful to someone, as long as you're not just being downright mean. You know, we can have difficult conversations, or we can have conversations that push the edges on it. But you know, sometimes people give them moderators hell over on Judge Fleischer's court, and we just need to understand, you know, time and place for everything. There's just a time and place. Absolutely. And Lena says she's not so tough on there. So she's you know, she's not as tough over here. Mummer's here. Moments of Justice. How are you doing tonight? Well, we're going to jump over to Judge Milton. A few weeks ago, we played a DV domestic violence hearing, and the judge found him guilty, but he hadn't sentenced him. Today, we've got the sentencing on that. We've got the follow up to it. It goes similar to the hearing went. All the same players, all the same people. So we're going to jump over to that one here.
All right, Mr. Schoolcraft, come up and have a seat if you would.
While he's going up there, remember to hit the like button, subscribe, and all that other stuff. Thank you, everyone.
All right, it's 10:37. We're close enough to on time. This is the sentencing in a matter of People versus Brandon Bartell Schoolcraft. File number is 24649SM. Mr. Schoolcraft was charged with aggravated domestic assault, and the matter was tried as a bench trial before this court earlier this late summer. The defendant was found guilty by the court, and the matter was set for sentencing today. The court had requested a pre-sentence investigation because still had a lot of unknown quantities here. Attorney James Mequio, Special Assistant Prosecuting Attorney for St. Joseph County, is present with us on the Zoom feed. Mr. Mequio tried this case on behalf of the prosecution. John Bush represented the defendant at the trial. Since then, the defendant has retained attorney Anastasi Marcu, who is here with us in court this morning. Also present is Autumn Kiefer, who attempted to do a pre-sentence report, got only so far. And our complainant, Leslie Schoolcraft, is present, and the victim advocate from the prosecutor's office is present. As I indicated, even though I heard this case at trial, I still had a lot of unanswered questions about the defendant and this whole circumstance. So I asked for the pre-sentence. The defendant had retained Mr. Marcu, and there was discussion of an appeal or something. So he was reticent to provide much information. So good morning, Mr. Marcu. I'll start with you.
Good morning, Your Honor.
What's your position here?
Your Honor, is the court asking for allocution, or is the court?
Yeah, no, allocution.
Thank you, Your Honor. So, the court and Mr. Mequio understand, I advise Mr. Schoolcraft not to speak at all about the substance of the offense. I did not advise him not to speak about his personal background or anything like that. But because he has a fundamental right to appeal a case if he chooses to do so, that was my safe recommendation to him, to make sure that he preserved any rights that he might have had. Regarding any possible sentencing in this case, this court knows that I was not present for the trial, so I cannot speak about the facts that were elicited at trial. However, as to Mr. Schoolcraft himself.
Hey, I hate doing this. I hate doing this because I don't like interrupting it. But Bodie, you had made a comment about getting banned or getting timed out all day. As a judge, a lot of people. Just to give you a heads up, sometimes those comments are moving so fast that the wrong person ends up getting timed out, or the wrong person ends up getting their message deleted. I don't know if that's the case in this. That's not my business or my concern. I just want to let you know that sometimes if you put hi and your comment gets deleted, you can be assured that the comment before yours or after yours was the problem, and it was just moving so fast. Even as slow, even on my channel, I'll go to hit a comment, and sometimes it'll hit the next comment because things move. So, just if you made a comment that was kind of risky, the kind of rule is if it's risky, go ahead and delete it. If you have to guess about it, go ahead and get rid of it. But sometimes somebody will say hi and they'll end up getting timed out, and it was just simply a clerical error. So, but you asked if all judges allow people to walk in and talk to them. No, Judge Boyd, you can't get into her court because of security issues. You have to have court business there. Judge Fleischer's, yes, I've seen him talk to people, and he's told people stop on by. You can, it's a public viewing. Judge Boyd sees it that her YouTube channel makes it a public viewing, so that makes her compliant. But not all judges. I would call the court clerk. I would call during business hours and just ask that way. That's the best way to find out about how that judge feels about it. And each judge gets to run their court the way they do. So we're going to jump back into it.
The court can see that while he did have a criminal history when he was younger, the last substantive offense would have been in 2009. That's now 15 years ago that he had any sort of either felony or misdemeanor behavior. That's a long time in which he has demonstrated a change in his behavior. All the other criminal offenses all occurred before his age of 24, when he was a young man, probably doing things that he shouldn't have been doing. Some of them were actually when he was a teenager. So I would ask the court to consider that because his last offense is at least 15 years ago, that the court consider that in fashioning any type of sentence. Mr. Schoolcraft has also been employed at American Axle for 11 years. Any type of substantial incarceration would most likely result in him losing his job. While he could take some personal leave, I don't think there would be enough personal leave available for a 93-day jail sentence for him to be able to maintain his job. Having a job for 11 years is a substantial positive. This court can weigh that against what the court heard at trial to decide how that affects the court's sentencing in this. What I'm asking the court to do is to consider instead a short jail sentence, 14 days or less, with a term of probation of 1 year, to make sure that he is complying with the law. If any domestic violence counseling is recommended, I know he'll do everything that he's supposed to do. The court can see that even when he was young, he was able to at least on at least one occasion be able to successfully complete his probation. Now that he's a mature adult, he knows what his responsibilities are. If the court tells him to be somewhere, he'll do it. If the court tells him to do an assessment, he'll do it. If the court tells him to complete counseling, he'll do it. He'll do whatever the court tells him to do. So my main 2 points are he's been crime-free for 15 years. He's been able to be a contributing member of society for that time period. He's had a great job for 11 years. I just don't want him to lose that, Your Honor, and that's what I'd ask the court to consider.
Thank you. Mr. Meckwell, before we hear from you, I'd like to hear from the defendant, and then I'd like to hear from the complainant, and I'll give you a chance to speak. Mr. Schoolcraft, what do you want to tell me, if anything?
I really don't know. I'm just, there's so much stuff that you didn't hear. I don't know. I'm just trying to,
Let me ask you a couple of questions. You're still at American Axle?
yes,
What shift are you on?
second.
Where are you living?
Currently I'm living in my truck. I am staying, like, sometimes I can stay like my aunts or friends and things like that, but mostly I'm in my truck.
Where's your aunts?
3 Rivers.
Are you contributing to the family expenses?
What do you mean?
Your house payment, food for your kids, the light, heat bill, that sort of thing?
I mean, I'm paying $403 a week in child support.
All right, so there's a child support order in effect.
Yes,
When did that take place?
I believe in July.
But you're not yet divorced, correct?
No,
All right, so there's an interim support order.
yes.
All right, well, that's something. Are you working overtime?
When I can. It just depends. Some weeks I can get Saturday, Sunday. Some days I can stay over. Just sits up and down.
So you take all the overtime you can get.
Yeah.
All right, Ms. Schoolcraft, would you come forward, please? Thank you. You're Leslie Schoolcraft?
I'm Leslie Ann.
Yes, you told me that, and I apologize, I
That's
forgot.
okay.
Let me change that. You were here at the trial, and I heard your version, and I heard your version, and I believed yours. I believed Leslie's version over Brandon's version, which essentially means I didn't believe Brandon was telling me the truth about what happened. As Mr. Marcoux indicated, he's working at American Axle. He's paying $403 a week in support. You got kids with special needs. I don't know, frankly, how you do it. You're working, you've got children that need extra help. I don't know, there are enough hours in the day to do everything you do and sleep. But it used to be for both of you. Now you're carrying most of that burden yourself. What would you like me to know?
I did write a statement.
All right.
Your Honor, I would like to address the courts today because speaking to Brandon won't matter to him. Honestly, he doesn't care. I've tried many times since trial and he has never taken accountability for assaulting me since it has happened. He's shown zero remorse. He's never felt bad for what he's done. He's upset that I stood up to him and stopped allowing him to hurt me for the first time. After he attacked me that day, he ran from our home. He showed up the next day for his belongings. I gave him even more money, packed all of his belongings in his truck before he arrived, gave him a hug while he was completely disrespectful to me in front of the officers. He then left out of state for 4 days. He had no contact with me and his disabled children. He did not check to see if the kids were okay after having to witness their mother be attacked. He never asked if I was okay or needed medical treatment. He just moved on with his life and has told everybody lies about what has happened. He has sat here during trial and he never looked up for him from his phone while he was texting. Unless he wanted to tell his attorney something. This case has been a joke to him. It's been how to beat this case and how to hurt me and our kids. I've been through so much already with the tragedy of losing my daughter in an automobile accident in April 2020, where my daughter burned alive when she came out of the covered bridge. I won't sit here today and say he hit me and knocked me unconscious and broke my tooth because I could care less about what he has done to me. Your Honor, I didn't lose anything that day. I actually got my freedom back. My daughter, my granddaughter will look down from heaven and not have to see me being treated this way anymore. When I look back at the day, I'm severely traumatized. I have panic attacks and I now shake uncontrollably, thinking about being around him again. The damage he has caused our children is what makes me have panic attacks and cry uncontrollably. And not able to sleep at night about what's coming next. What has happened because of the events that happened on March 26th, Brandon has realized that he can't hurt me anymore unless he hurts our children. So if he doesn't care enough about the traumas that he has caused our children because of this day, he definitely does not care about what he has put me through. What has happened since this day when he attacked me in March is he has continued to do things to try to hurt me. He's came after my job and caused issues with me with my employment. He's came to my home and threatened me to the point where I had to file for a PPO so that my kids had a safe place and he wasn't able to come to my property any longer. He worked 12-hour days so that he could stay after work until 10 a.m. to work over on my shift. He would then wait in the parking lot until 2 p.m. when I left work. And he would leave after I left so he could keep tabs on me. I had to call the prosecutor to get him to stop. That's when he started claiming that he lives in his truck in the parking lot. He has met me 4 times since August, but refuses if the kids are around. This is a way for Brandon to control me. He will tell lie after lie to get away from the things, to get away with the things he has done. But Your Honor, he's not hurting me. He's hurting our kids. I won't sit here and say I want him locked up. I won't say he deserves this or that because that will only make him hurt our kids more. What I will say is I don't want him to lose his job. I don't want him to suffer at all for this. I do hope that he gets counseling and anger management, whether that's on his own or through the courts. He has a major issue with his anger. His anger gets worse when he drinks and eats edibles, and he takes his anger out on me and the kids. I don't wish bad on him at all. I hope that one day he finds peace and he stops trying to punish me and the kids. Brandon, today is a clean slate. Now it's your choice where we go from here. Hopefully it's forward and moving up because we've always been a team. We're better than this, and most of all our kids deserve better than this. I hope you get the help you need.
Has he seen the kids?
Very rarely.
He
told me that he can't see the kids unless I drop the PPO. So I dropped the PPO so that he can see the kids. And he's met up with me 4 times at work, but won't see the kids.
All right, so you've got 2 autistic children that you're raising by yourself. Putting to bed, getting up in the morning, dressing, getting ready for what they have to do during the day. You're doing all that by yourself. He's not involved, obviously, in any of that.
He works second shift, so now I begged him to come to first shift. He told me he couldn't miss the PPO. I dropped the PPO so he could come to first shift, so he could see his kids. And nothing is good enough. Nothing that I try is good enough. I even sat in my truck a week ago when my son had to have emergency surgery so that he could be there. And I barely got updates. The one thing I asked for was, can you at least tell me how long surgery is going to take? And I wasn't even allowed that.
Now, there was a strange dynamic of he had a female friend who wanted to meet your children, was or was not a girlfriend. I'm not real clear on what that relationship was. Is that person still in the picture?
Yes,
So he has a female friend who may or may not be his girlfriend.
yes, but I don't think she wanted to meet the children. I think that they were just at the house so that they could spend time together.
Yes, your allegation that they would come to your house while you were at work.
Yes.
So your contention is he gets out of work at 10 and sleeps in the parking lot until you get,
Well, he's on a different shift now. That's what he was doing up until I think it was 8-5. He switched shifts. And went to second shift. But before that, when he was on third shift, he would stay over until 10 a.m. So he worked halfway through my shift. And then he would stay in the parking lot until 2 when I left, and he would leave the parking lot about 2:20. And then he would go back to her house in Sturgis and then do it again the next day.
her house being the other.
The girl.
Okay. Also, I'm very sorry. If I knew the Bingaman girl was your daughter, I'm very sorry. Are you the one that keeps up that little memorial there?
It was both me and Brandon until he left, and now it's me.
Was it his daughter also?
No.
I drive past that every night on the way home to work. And I remember it was bad, but I smile at the fact that somebody is maintaining that for her memory. I thought, well, her family must have loved her. I didn't realize it was you and you. So I'm sorry for your loss. Yeah, I see it every night. And it's always well maintained and updated. And so you got that burden also. He was talking to you about dropping the PPO, which in and of itself is a violation of the PPO, but PPO has been dropped. People often stop me in the store or they say, hey, I watch your channel. Thank you. But you need to throw the book at these people. You're too soft on everybody. I get that a lot. There is a statute in Michigan that says there's a presumption that there won't be any jail. Fine and costs only. There won't even be a probation, but this case certainly overcomes that presumption. There's an underlying issue here about the defendant's employment. He isn't going to get a prize for Dad of the Year right now, but he is paying $403 a week in child support, which would go away.
He does pay his child support. He does pay his child support.
As well as the benefits that he has. Mr. Mequio, you were here. You presented the people's case. What's your position here?
The court has heard the testimony, so I'm not going to revisit any of the trial. As the court knows, there are varying degrees of domestic violence, from maybe just a shove or grabbing a cell phone to what we have here, where we have a physical injury. One of the things I remember from this trial is the exhibits with the blood stain on the carpeting, which was fairly significant, which to me showed that there was some pretty extreme violence that was used in this case. I know the probation officer was limited on the information and isn't recommending probation, but given what I've heard from the victim and also the possibility of substance abuse issues, I believe that a significant time of probation with some at least conditions involving counseling and perhaps anger management and perhaps family counseling, and certainly substance abuse issues should be dealt with. I would recommend, Your Honor, a reasonable length of probation, 1 year at a minimum, I think, perhaps a little longer, given what the counseling efforts may need. The victim doesn't want the defendant to lose his job, and I think that that makes sense. If it wasn't for that, I think I would be asking for a significant amount of jail time, but I'm going to leave that to the court's discretion, hoping the court can fashion a remedy that will punish him, but also allow for some rehabilitation, and most importantly, give him the ability to continue to support his children.
Do you believe he's actually living with this female friend?
I do believe he's staying with his aunt most of the time, but then I do believe he stays with her. I don't really care where he stays. He can live wherever he wants. But I do care if
something needs to be better than living in your truck.
If he is put on probation and there's a no contact with me, then he won't see my kids. I want him to see my kids.
So you don't want a no contact order?
I want my kids to be able to see him. My 7-year-old is struggling really bad.
Well, for example, if the divorce were amicable, he would
He
have,
can have whatever he wants.
he could have, you'd get a weekend off. You're on duty 24 hours a day, 7 days a week.
There's things that you guys don't know that I can't say. I'm sure that
All right.
prevent it. It has to be supervised.
All right. And at some point, maybe we'll get to that point.
Your Honor, it's my understanding that both of them have family law attorneys. And the hope is, as the court knows, when things like this happen, it may take a little while for things to kind of normalize. But I know that Brandon wants to be able to see his children and to be able to be the parent that I think the mother wants him to be. It's just going to take a little bit of time for that to happen. And I think both of them should be patient with it.
We also can't punish a 7-year-old. A 7-year-old can't keep waiting for his dad.
Well, the kids don't understand, and they wonder, what did I do wrong that my dad doesn't want to see me? And there's nothing good about it. As I mentioned, there were several weird side stories to this case that never were resolved. The cans of alcohol in the sink, the fact that everybody's asleep in the middle of the day in a pitch dark house, this friend that's not a girlfriend, the fact that he allegedly walked to Kalamazoo in the middle of the night in March. His version versus your version, and as indicated, I believe the complainant's version. So I believe that he didn't tell me the truth about what happened. And I don't believe he's remorseful. You regret the whole thing that you're here, but you haven't owned any of this. Ms. Kiefer made a recommendation of 93 days, I think maybe a little bit out of frustration. Mr. Marco explained why I wouldn't let him talk to you. Anything else to add on him?
Well, unfortunately, like I said, I wasn't able to talk to Mr. Schoolcraft and get a full report completed as I would have hoped. I did read the police report prior to my interview that was supposed to happen with Mr. Schoolcraft, and learning here today the things that I've heard from Leslie Ann. He needs a probation. we're not out for someone to lose their jobs, but this is a severe offense. There was a lot that happened. So I'm not, I believe that there should be jail included, whether that be work release, and we give him time to get that paperwork back to Twin County. And he do that and work at the same time. But I would recommend that if he's on a probation, it would be a 24-month probation. He would do the full 2 years. The 26-week domestic violence group, substance abuse assessment, random testing. As Leslie Ann has just stated to me, she wants a no contact in this case because of the children. Obviously, this court can't enforce that parenting time, but we can make sure that if they do have contact, that there isn't any assaultive or threatening behavior during that time. But I do believe that there should be some jail in place on top of the probation.
All right. I am gonna go with a 24-month probation because the defendant's successful at it, he's entitled to have the probation discharged after 12 months. If I did a 12-month probation, he could theoretically be entitled to discharge after 6 months. I agree with Ms. Kiefer. He needs the full domestic violence treatment class, not anger management. That's something less significant. He needs the domestic violence full class. He's not eligible for a deferral because he has a previous conviction, but he could benefit from the class, both as a parent and in your divorce. Mr. Schoolcraft, as you successfully complete the domestic violence class, A, it'll make you a better person. B, it will impress Judge Pattison that you may be somebody worthy of visitation and maybe even part-time custody. I'm going to order 93 days jail, credit 1. That means there's 92 days left to serve. I could do it several different ways. I could do it 92 days flat. I could do work release, which I'm a little reluctant to do because it's more expense. It's sort of 6 of one, half dozen of the other, or weekends. Weekends takes away his ability to do overtime, but it maintains his job. So I'm going to do 93 days in jail. Of the 93 days, 78 are deferred, which means there's 14 days to do on weekends. And if they'll accept a work release for 14 days, I would allow it. But you're going to miss most of the football season because you're going to be in jail every weekend for 7 weeks to think about this. The fine is $0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $960 probation oversight fee, and pay for the class. I am ordering the full domestic violence class, substance abuse evaluation, no drugs and no alcohol. And testing as demand also means you can't use marijuana. You've got gummies or vapes or whatever may help you get through life. But while you're on this probation, you're going to be clean, which will also impress the judge in your divorce case. No alcohol and no controlled substances, no assaultive or threatening behavior. I've got 78 days held over your head, but this is a 1-year misdemeanor. In reality, there's 364 days that I could allocate to this. Mr. Marcoux, I left this up. The bench trial is on, at least I thought it was. Maybe I deleted it. I let things run for about 30 days and then I remove them. Although I think maybe I took this down by mistake. So you could have watched it. But nonetheless, I made the finding that I did, and I stand by it. you're gonna do the full domestic violence class, which right now sounds like that really sucks. However, it doesn't suck, and I think you're gonna get some benefit out of it. There's a bunch of issues, as your wife said, and you said, there's stuff going on that you can't tell me. And I don't know why you can't tell me, but I am aware there's stuff I don't know. She wants you to be a parent to your kids. She's not gonna be in a relationship anymore, or you moved on. But her life is really hard. And it's no picnic living in your truck. So you're gonna have to get a permanent residence. We're not gonna have an address of a license plate number. Anyway, that's my order. I want you to go downstairs to the probation department. And they will get you plugged into this. We'll set up the testing, which will be random, and the treatment, which will be beneficial, and when you're gonna serve your weekends in jail.
The court gave them the option of 14 days work release if they're allowed to do that, correct?
I don't know if they'll take a 14-day work release.
I don't know if they will either, but I.
Generally,
think
in
it's
order to
worth
do
them
work
to
release, you
explore.
have to do at least 30 days. So
I know that American Axle will oftentimes have him come in and work on Saturdays, and it could be part of his employment, and I know he.
Well, then he'd have to do one day at a time. So it'll be.
So he can work around this, great, right?
Yes. Mhm.
Okay, you'll do it, right? Okay, all right. Good.
All right, Ms. Kiefer, thank you for your help here. Good luck to you. I'll think about you every night when I drive home. Have you finished your other case, Marissa? All right. Is Jeffrey Sherrard here? Why don't you go ahead and bring him in? You're gonna stick around for this one, Jim?
Oh, that's right, so.
So imagine having a hearing like that, and you end up talking with him, and you find out that the memorial at the end of the bridge was her daughter. You drive by it every year, and you see her daughter out there. The memorial that adds makes it a little bit more sad. Jay runs the show, Tokyo, so we're gonna have to go over to Oakley. So give me a second. Let me pull up the Oakley one from today. He had a good one, so let's go to that one. Yep. Oakley will lighten things up a bit. There.
All rise. Court now in session. Honorable Judge Oakley presiding.
Come on, Mr. Cressell. You folks can have a seat. All right, appearances for the township. Have a seat, make yourself comfortable. All right, so Mr. Cressell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, especially with the additional bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Cressell?
It's covering all the additional bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have the state history to me telling you didn't give a shit about what I had to say.
Okay, hold on. Listen, Mr. Cressell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers just Gene Green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Cressell, hold on. Okay. That's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
Prosecution against me this entire time. No one has made her answer that.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept? I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, that means you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Cressell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
Yes.
It is. All right. So now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that?
It was,
I thought we were talking about Judge Green's SOS statement.
When you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that all aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside and what you were doing.
Mr. Cressell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt. Anytime I tried to.
I am threatening you with contempt.
My objections on the record, you make my case.
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me, is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me, because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately, properly, and to be perfectly honest, in your best interest.
And in your honor, again, you're trying to spin this here.
I'm not spinning.
My objection is based on you not allowing me to do it. And that's when you told me my objection to be.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once it's on the why it's on the prosecutor to prove those things. There's all sorts of irregularities.
All right, let me let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You're supposed, you need to.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me being able to get all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Like put on record that if whatever you would like to do from there, you can, because I'm open until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
Arrested Mr. Cressell while he was in Huron Township, 34th District Court has jurisdiction over offenses that occur within the township, both civil and criminal and.
Did you appeal Judge Green's decision on that motion?
I'm investigating because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct? I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to.
The judge can't just come in here and say that there's.
Yes, the judge can. Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was sending aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And anybody, I have all the recordings and they're submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, the judge said that.
Fine. Then I'll say the same. I'll say the same thing to you. Listen to me. Here on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay. Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Cressell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So that's 2 motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen, the thing is,
Mr. Cressell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no? Yes or no? Do you want me to set aside those default do you want me to set aside the default set asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
essentially, yeah.
Okay. Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Oh, excuse me, motion for judicial notice. What does that judicial notice of what?
Certain terms, everything that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used. Okay.
For example.
You use motor vehicle.
Okay. Motor vehicles pretty much a term of art in our business.
Law of differences between how it's being used. Absolutely.
Well, then you can make those arguments, but you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything is taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cressell. No, Mr. Cressell. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the 4th or 5th time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
And that's the other issue of the trial, and not emergency stop, motion stop.
I already ruled on that.
Certain back, acknowledge my motions for my next travel.
Once again, I'm not trying to, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right. I am open-minded enough to think that perhaps my mindset about your whole travel, whole thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
I said, well, you just keep, each judge has done the same thing. They just keep setting it aside. And acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my head.
What's your case that traveling doesn't mean operating?
I'm accepting the fact that this court's violated my due process rights in every way, the judicial bias and the.
All right, then appeal me. But today we're having a jury trial.
An unlawful jury trial, and I think that late statement I need to get on the record.
But hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it.
Okay.
It violates my rights to a fair trial. 100%. And you want to keep overlooking, I know they make you seem like they're not a big deal, and
No, your rights are a really big deal.
obviously not, because if you can sit there and say that the things that are happening, the things you're saying, and just try to give these excuses, oh, just because I agree with her on this, you are aligning yourself with the prosecutor on my right to trial, completely setting aside, not allowing me.
Mr. Cressell, no, I'm not. Listen to me. No, it's not. Listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. Traveling, the right to travel was when you did it by Shank's mare. Then appeal me. That's my decision. Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
Rulings from the American Jurisprudence side that literally stated that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this is something that's been established to be secure.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process we're having now.
Which is not an appeal.
Is an extreme, lawyer when there's bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure. Yes, you have.
I'm forced to be here.
But you didn't have to do it. You didn't have to do it as an untrained layperson. You had free access to qualified, competent legal counsel. They're still here. There's one right there behind you. He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then I'm taking sides. Now, I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There is no partial anything. I have the.
Once again, Mr. Cressell, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to meet my wife days before any of this even happened. and talked to us about the traveling. Even told me I was well within my rights, gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me, he even called me trying to overrate. I was like, well, it's not overrate. And then he goes towards the motor vehicle. And then he tries to get me to not pursue legal matters. And then he's mad at me. And then the day that I file for my body cam, I'm getting removed from here on a Little League.
And none of, stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here, and I told you that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, every time I force it to make my case, basically, the court just keeps setting all my stuff and not allowing me to be heard.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How will there be facts if this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my defense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single and just not even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury?
No, it's not. I'm not testifying. That's what I'm saying. It's the amount of traditional bias in this case.
I'm done hearing about bias. You need to appeal me. I don't feel I have bias.
Well, I don't feel that I would have a fair trial here with everything that's been taking place. Why I filed policy? Why did we?
And I've denied all these things.
Well, of course you can deny it again, showing again that this.
Once again, Mr. Cressell, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion?
Tina Green told me that she was just not acknowledging myself because the Secretary of State will make sure that this isn't a big deal. Right? Showing.
I'm not going to.
It's no impartial sport here.
I've never brought a Secretary of State, have I?
This is where this all stems from. These are the things I've been trying to get noticed. This thing talked about.
What do you want getting noticed that we're not getting noticed?
The fact that this collusion
is not collusion. What? All right, listen. What are you going to do today? Because I'm ready to bring the jury, and I've denied all. Stop! I've denied all your motions. I'm ready to set the trial. Are you not going to be here?
Nothing is even put in here, right? And especially regarding the jurisdiction stuff.
Once again, we're at $300 now. We're going to 4. I'm going to ask you the question again. I'm ready to call the jury. Are you going to leave?
There's no way they're going to be here trial.
That didn't answer my question. I need to know how I'm going to proceed, because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself, and you might not say anything today. So that's the way you want to go with the trial.
I do. So it's against that.
Okay.
Everything is on the record.
Okay. Okay. No, let's on the record as you feel they should be.
I brought the sites that I left the sites at home and bring up the person's jurisdiction.
And hold on. Once again, I want to just, because he just walked in the room. Once again, I want to let you know there's a very competent, experienced legal attorney here, defense attorney here, that's more than willing to help you with this if you want his help.
Well, the sport actually who is supposed to be.
And that ain't gonna happen.
Anybody showing you were supposed to reduce yourself. It's in the book.
And I don't think I've shown bias. That's what we keep. Once again, you and I disagree. That's okay. That's America. You have to appeal me. You don't just keep to argue. You don't get to argue the same thing over and over and over until I agree with you. That's not going to happen. I know I am not biased towards you. I also know that your ideas of how the law applies in mine are vastly different. But because I'm in the black robe and I'm in charge of this trial today, my ruling stands until a circuit court judge or some higher court tells me I'm wrong. That's just the reality of it.
That's what I have to do. Because this court's not going to rule it the way it's supposed to. I'm not going to stand by your jurisdiction.
Not by your definition, I'm not.
Secretary of State, Attorney General, and you. I've never heard anything. I don't even know if you're lawfully allowed to proceed it. You can say that again. It's been proven on the record.
No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to prove that. Statute, Michigan statute or Michigan court rules says they've got to do that.
I have it in there. I thought it was in this motion.
So you're such a great legal scholar.
MCL 168.420 and MCL 168.467 mandates that the judge must file an oath with the state, and you provided one X. That is what you have to ensure.
Okay, then I don't have it. You can file that motion to dismiss with the circuit court. But we're having a trial today.
We're gonna have a ongoing participating trial that's going to be impartial against them, right? It's going to be completely. There is no impartiality that is supposed to be here. There cannot be a fair trial for all of the amounts of evidence that they have.
Okay. Anything else you want to put on the record before I call the jury in?
Yeah, lengthy statement I would love to put on the record before we get.
How lengthy?
Minutes.
Go ahead.
Respectfully, sir.
Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Showcase the record.
Your Honor, Judge Oakley, respectfully, sir, this court has failed to by files of the case. Yeah, well, then so she can make. I respectfully, sir, this court has failed to address the critical motions I filed in this case, including a motion to dismiss for lack of jurisdiction, a motion to recuse for bias, and a motion for relief from judgment. These motions have raised significant concerns about the court's jurisdiction, judicial bias, and violations of due process under both the Michigan Constitution and the U.S. Constitution, particularly the 5th and 14th Amendments. I have also submitted affidavits and motions, including an affidavit of truth and an affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case on August 21st, 2023. Citation number 24HR-10143, which this court also ignored. These documents directly challenge the jurisdiction of the state in this court, and failure to address them constitute a violation of due process rights. Additionally, I have filed an affidavit of not consent, a motion for judicial notice, a motion for clarification of accuser, none of which may be outside the court. In Marbury versus Madison 5 U.S. 137, the U.S. Supreme Court clearly established that any law repugnant to the Constitution is void. I believe the action or lack thereof of the court violate fundamental constitutional principles. In Murdoch versus Pennsylvania 319 U.S. 105, the court reaffirmed that no state may impose fees or penalties for exercising a constitutional right. And Thompson v. Smith 155 reinforced that the fundamental right to trial freely without undue interference. Additionally, Title V USC 556D, 557, and 706 require that any judicial or administrative proceeding be fair, free from bias, and based on factual evidence. I have serious concerns that this court has disregarded this evidence. I have serious concerns this court has disregarded these principles, given its method of dismissing my motions and statements made by Your Honor, who has stated on record that we see things the same way, referring to the prosecutor, township, state, in this court. This admission clearly demonstrates judicial bias and lack of impartiality, which undermines the fairness of these proceedings. It is also significant that Judge Tina Green has admitted in court that the Secretary of State is influencing the rulings, stating that the court is required to enforce certain rulings because of the Secretary of State makes them do so. This further demonstrates that this court is not acting as an impartial judicial body, but is enforcing motor vehicle codes, other rulings based on external directives rather than applying the law independently. The Secretary of State is an executive branch agency, and his influence over judicial proceedings is a violation of the separation of powers and the constitutional right to an independent, fair trial. Furthermore, there is clear evidence between the court, prosecutor, Huron Township, including the Huron Township Police Department. I have submitted body cam footage highlighting violations of department policies by several officers, including Officer Merrill, Officer Stein, Officer Smith, and Chief Everett Rollins. These violations occurred even after Sergeant Price confirmed that my activities were lawful. Yet this court continues to overlook these crucial facts. Officer Merrill's traffic stops of both myself and my wife are connected to the ongoing retaliation against me and my family, which has compounded the bias and misconduct in this case. Additionally, I have requested Your Honor's oath of office through an affidavit of fact, registration statement, demand request pursuant to the Foreign Agent Registration Act of 1938, and anti-bribery statement request, and I have received no response. This lack of response raises further questions about the legitimacy and legal standing of this court. Moreover, Judge Lisa Martin issued an unsigned default order without jurisdiction or court seal, and during court proceedings, she admitted she did not understand the sui juris. These actions reflect further incompetence and violations of due process. I must also address the township's deliberate attempt to mislabel my private automobile as an off-road vehicle under local ordinance to circumvent our constitutional right to travel. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private, non-commercial travel. This ORB ordinance was never intended for law public roads. Under the Federal Trust Code, United States 318 U.S. 363, when government entities operate in a commercial capacity, they lose sovereign immunity and are subject to the same legal standards as private corporations. The court's actions, including the misapplication of commercial motor vehicle codes, further demonstrate its commercial interest in misinterpretation of the law. The supremacy clause of the U.S. Constitution, Article 6, Paragraph 2, mandates that this court is bound by the Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard for constitutional protections, violating my rights at every stage of these proceedings. To continue under these circumstances would be a violation of my constitutional rights and an abuse of judicial power. I respectfully request that the court issue rulings on the pending motions, including a jurisdictional challenge, they immediately dismiss this case by citing overwhelming evidence of judicial misconduct, bias, and due process violations. So these issues remain ignored. I will seek immediate appellate relief, hold all parties accountable, including Your Honor, Judge Martin, Judge Tina Green, Prosecutor Caitlin Margaret Foley, Officer Miro, Officer Sy, Officer Smith, Chief Everett Robbins, and the Huron Township Police Department. I further assert that if this court continues to proceed under the presumption that I am engaged in commerce, it must present evidence to substantiate its claim. Without such evidence, this court has no authority to enforce commercial motor vehicle codes or ORD ordinances upon me, and any further actions would be unconstitutional and unlawful.
All right, here to court this report back in session.
Bring the jurors in. Mr. Cressell, just so you understand the process, we're going to do voir dire. Did you have a chance to talk about the iPad?
No.
Hold on a minute, Joe.
Yeah, I told him I would go over it.
Okay. I understand that's your position, but I'm still going to explain things as they go. All right. I mean, I just want you to understand what's going on. So if you decide you want to jump in, you'll know where you're at. Understood? I'm not trying to talk you into participating. I'm just letting you know what's happening. I'm going to explain things as we go for you and them. You got that?
I suppose I don't understand why I need to sit here and use my time for an other.
Because if you leave, I'm going to ask you a bench warrant and you're still going to have to deal with this down the road. At least this way, listen here. One of two things can happen today if we have the trial. Either they find you not guilty and you're done. Then you can file all your grievances and stuff. Or they find you guilty and you're just filing one more appeal.
Instead of wasting everyone's time.
You've already wasted their time because they're all here. They're all here.
Well, that's why I filed these things weeks ago. These things should have been addressed before this process even took place.
There's a scheduling issue that takes place too.
So
but hold on. Hold on. Don't interrupt. You didn't appeal the last round of decision. You didn't appeal the decision you didn't like from Judge Martin. You didn't appeal the decision you didn't like from Judge Green. And you didn't appeal the decision you didn't like from me last time you were here. So here's my problem. I'm not going to adjourn today because you say you're going to appeal, because if you don't, we've accomplished nothing and we're no further to resolving these files.
I've been in contact with the appeals court.
Okay, hold on. Let me try to educate you. Okay. You contacting the appellate court, first of all, this should go to the circuit court. All right. You've gone. Okay. So I didn't choose for you to be here, but you're here. Okay. So we have to get through it. All right. So the way it works is you don't just talk to them about an appeal. You actually file and perfect an appeal, but you didn't perfect the appeal. So there is no appeal. You started the process, but there is no appeal. So we're going to go forward today. The only question is, are you going to be in the chair or not?
No, again, if you were prevented for, I'll participate on one, correct?
Depending on what I set the bench warrant at. Can be whatever I want it to be. Once again, but see, you think that's bias, right? And that's me explaining to you the way the process works. I could set a $10,000 cash bail on this. And until a circuit court judge tells me that's got to be set aside, it's the bail. That's the bond I set if I set it. Because here's the thing. And I'm trying to, listen, dude, I'm trying to get you to see I've got a job to do. It's got nothing to do with you personally. All right, you keep bringing this, you know, I'm having so much trouble getting through to you. I'm thinking the next step is a competency exam.
So that fact that she told me that on the record in front of her, and in all the things that she's saying, the judge said, she never said that on the record. I have the record submitted.
So once again,
she wasn't doing this because of the Secretary of State.
Then appeal Judge Green's decision. I've told you that at least 5 times today. If a district court judge makes a decision you don't like, you appeal it to the circuit court. You don't just keep arguing again. That doesn't get you any further along. So if you don't participate today, if you just sit there, that's fine. We'll have a trial. You can jump in if you want to. You don't have to. I mean, in any criminal trial, the defendant doesn't have to do anything. But at each step of the game, I'm going to let you know what your options are. So for example, when we do voir dire, I'm going to ask questions of the prospective jurors. She's going to ask questions of the prospective jurors. You can ask if you want to. You don't have to. All right. When it's time to pick the jury, she has a certain number of challenges she can use. So do you. You don't have to exercise those challenges, but that's the way we pick the jury. Do you understand that process?
I've been trying to get all this stuff established as a court routine. And I still have evidence that I'm trying to get from the township that they're using lead codes for that, which they did with the policy information that I tabled and got them to give me the policy because they were trying to do things on.
Okay, stop right there. Hold on. Stop right there. Stop right there. That's something new evidence you're waiting for. What are you waiting for?
I haven't got it to even get to.
No. Tell me what it is. What?
Evidence that way that I requested from FOIA's in the very beginning with my bottle camera.
No. But what is it? You're looking for some records, some ordinances? What?
Part of the traffic comments and things that were put in there. That
Hold on. In where?
In the comments.
You don't have police reports?
Well, I do, but I found out that they withheld certain documents that when I filed my FOIA, they didn't give to me. And then upon doing more filing for more stuff, I uncovered that they withheld certain documents. Okay. That are getting the whole thing.
Hold on. Let me hear what you just say. Just hold on. Go ahead. Do you have any idea what he's talking about?
He's bringing things from the south.
You mean like the officer's personal notes? Had notes.
And for example, body on camera where they're sitting in their patrol car and the computer's on. Those are all main material that can't be discoverable. It can't be shared with people outside those that are have the security clearance to observe or handle the material. So that's what he's referring to.
Okay.
That's not what I'm referring to. The notes on the computers and stuff, that's not what there's even stuff that was in the body cam that when they were talking to the chief that they purposely redacted out of the conversations and the notes that that are completely all redacted. It's nothing to do with computers. It has nothing to do with personal information and names or addresses. There were things that were stated in conversations that were taking place in these notes.
Let me stop you. During the traffic stop?
They withheld this when they should have given it to me in the very beginning with my FOIA for everything that's involved in my traffic stop.
Okay, hold on. I'm trying to clarify. Are you talking about like, how do I want to say this? Personal comments between 2 or more individuals?
No, it's not personal comments. It's stuff that's logged through the traffic stop. Like,
No, stop. But I got to understand what you mean. Logged through the traffic stop. You mean it showed up on camera and then they edited the camera?
Yeah.
Or edited the recording?
As well. That there was no clear reasons why. Every time I'm trying to get reasons to why they did it, what it's next, because they're supposed to label why it is. I haven't got anything. And then it's in the comments sections of like what was going on.
Hold on. Comments on the incident report?
It was just, it's not the incident report, it was through the, while the traffic stop was taking place, stuff that was being entered through, like. I can't remember exactly what the paperwork is I have, like I said, I'm in the process of getting that all. I haven't, appealed it to the supervisor, and then he vaguely gave, just cited statutes and codes, but he was supposed to tell me how and why I didn't see the applying to the lead sections, which are failing to do because.
All right, so hold on. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. I think what you just said was those comments section things that you want, they're telling you that's all lien stuff and it's protected.
Yeah, it's like, but I had other.
Hold on. Is that a yes? That's what they're telling you?
Essentially.
Okay.
So, and part of the, I had a whole thing paper I got from them. They didn't do it in any of the other ones. Only.
Hold on. Other one what?
All the, because there have been several reports, several times the cops came out of their house, and we were told, well, this has been going on for all of the years, probably why it's even happened.
Okay.
So I filed all of every cop that had been there, all the reports, anything to do with anything that I could get that was access to me. And then that's how I found out that these other reports weren't released to me. And then in my life traffic stop, they did the same thing. Everything to do with that entire traffic stop is all completely redacted. We have any of the other stuff, it's all open.
Redacted from,
The whole page is just black.
hold on, redacted from the incident report?
Yeah, from the incident.
The paper report that you received?
Yeah, exactly.
Okay.
And there was no justification at all to why any of these things are redacted. I keep trying to, and how they did it with the policy. I tried to get the policy 3 separate times to the department, and then they cite these lien codes for names and addresses and stuff, which I understand there's certain stuff.
What policy?
The policy conduct for officer conduct and how the officer is supposed to operate themselves, right? So they denied several times, stating the same lien codes are trying to use all these redactions now. So I appealed it to the township supervisor, and he released all of my information, and it showed that the policy showed that these officers violated the policy. And
Okay, hold on, stop. So he released everything, but not everything you want?
well, then once I realized they were doing this, I went back to even more. That's how I found out there was more stuff that was under released to me.
Okay.
And then they're doing the same process using these lien codes to not let me see what was put in this paper. And that's why it's all the record titles. I've been trying and fighting all this full time trying to do this stuff together. And I'm getting every which way I'm being screwed.
He's raising issues that concern me. Because now we're talking about discovery requests that are being partially fulfilled.
As it was with this stop, he does have the incident report, he does have the body worn camera for 4 officers in car, dash cam, what have you. He also personally took a video. I don't have it, there was no mutual discovery. He elected to use the FOIA route to take all this information. What he's referring to again is the CAD information where there is no material. None of that affects what the substance of the incident report or the body worn camera or anything of that effect. He's also talking about incidents that I think they were probably about the township attorney is dealing with it as opposed to the township prosecutor. There's probably about 20 different contacts that he has sought FOIAs through. So it's not just this incident. And what I suspect he's talking about where police may have came to his house or like a traffic stop or speeding ticket, there are no incident reports, those are CAD notes. So that's probably why those are blacked out as opposed to this incident where a misdemeanor was attached and an incident report had to be done.
Okay. Anything else as far as information you requested that you don't have that you think you need?
I mean, that's the base of it. I'm still actually, now that I've been having to really dig into stuff, I'm uncovering more. Now that I've been through the body cams, I have to file more to get more stuff unredacted because there is clear points in these conversations that were purposely redacted. They have nothing to do with lien information that they keep claiming. Same thing with these CAD notes she keeps referring to. That's not what I'm trying to get hold of. And I understand that there are things that they can redact through the lien code. These entire things that are, there's no way the entire pages and these comments and everything are all lien information. I know that. I've been told.
How do you know?
I've been told for Sergeant Price, things that are said in these personally about me and stuff like that are being redacted because it can be used showing the bias and everything, retaliation against me. And I know for a fact what was said in these things. That's why I know that it's more than much to say.
Okay. But Mr. Cressell, with all due respect, that all sounds like a civil lawsuit against the township.
Well, yeah, this is my arguments I've been trying to bring into this court, but everything's just been keep getting.
Because I'm not gonna get into all that with a jury.
But that goes directly to this, is what I'm saying, and that's why I've been trying to get all of this stuff answered before we even come to this point.
I'm not gonna let you get into all that with a jury. It's gonna be confusing. We're gonna go down rabbit holes.
That's why
What's
because I need to be able to present my case to
Sure.
get a fair.
So this case goes back to February. We set this trial 2 months ago.
You're right, but
2 months and 2 weeks.
trying to get the jurisdiction established, I'm trying to get the judicial bias stuff taken care of, all of these things that have not, that they've just been it is what it is, getting swept under the rug. When
Okay, hold on. Once again, I have to take offense to that. I'm not sweeping your judicial bias argument under the rug. I'm denying it.
Without it, I give it, yes.
Okay? No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. Now, you appeal that decision or you grieve me to the Judicial Grievance Commission, right? They can look at all your facts and say, well, Oakley, clear bias. But I don't have to hear all your arguments and see all your evidence to know I'm not biased.
That's fine, I guess that's something, and I have already started the process, I will be going down it, the more I look at it.
Okay.
So again, I.
Sir, it's 9:02. The jury's been here since, I'm assuming shortly after 8, some of them were showing up.
Yeah, like I said, I cannot participate in something that I know is stacked against 100%.
But once again, you think it's stacked against you just because you don't agree with the way things are going. Okay.
It shows that these things have to be established, that there has to be.
Then
but that, to me.
Okay, stop. We're just hashing the same arguments again. If you're right, then you've got an automatic appeal if they convict you today. If you're right, and this whole thing has been nothing but a sham.
It has to be, and it's all this turned into.
Okay, bring the jury in. I'm tired of talking. Motion who? Oh, I forgot you file a motion. Give me just a moment. Yeah. Yeah. Did you see that? Hold on. Did you get her motion? Yeah, no. You got a copy. You can just at least show him so he can see if he's seen it before.
When did you send this to me?
Last Tuesday along with extra.
I have never seen this.
Take a minute to look at it.
Let's like to bring up for the record too that.
Hold on. Hold on. Have you had a chance to look at what you just handed me? Okay. All right. So are you ready to argue that motion?
Well, no, I had no time to prepare for anything except. I've never seen that before. And
Okay.
it's just trying to keep me from being able to bring up all my valid arguments that are all applied to this.
Once again, valid as you determine them,
It's advanced to the case.
as you say.
And that's, and they're the same with the things they're trying to say, right? They have no evidence. Where's the evidence?
Right. But I haven't ruled that anything she's trying to put in front of the jury is invalid.
So my defense to my.
Well, here, let's do it one at a time. She wants to stop you from saying anything about due process violations. Did you plan on telling the jury that your due process rights have been violated?
All part of this case.
Okay.
Same thing with all the traffic stop all the way till now.
Specifically, what were you going to tell them about your due process violations?
Well, I don't have my defense completely in front of me because I'm trying to get all the other matters. I'm not ready for that. So I've never even seen it, so I can't even build up a defense to that.
How was that provided to Mr. Cressell last week? Okay.
See his motion, or his $100 motions on Thursday, so he didn't much time to respond. I did send it in the mail, I dropped it off in the post office. this morning. And I didn't receive his most recent motion.
That was filed Friday. Right, right.
I said on my certified mail, so I know what you're saying. I mean, we've never got first last name. Never.
All right. So here's what we're gonna do. If you decide to participate and present any evidence to the jury today, then if any of these A through E's come up, we'll deal with those as a point, on a point by point basis. Understood? I'm not, sir, I'm telling you, you don't have to. She wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion. I'm not going to do that. If you choose to present anything to the jury and one of these topics come up, she's going to stop me probably with an objection, say, Judge, could we talk about that? And then we'll talk about that. Item by item. Understood? All right. Anything else before we bring the jury in? You said you wanted to say something before the jury came in. I thought you said.
Another key point to this, I filed for records requests in this court, trying to get all my court hearings and everything in recordings. There's still one from the very first one from Judge Martin that is crucial to this case. They still have issues.
How could it be crucial to the case today?
Second rule in there, absolutely huge to all my whole.
No, they're not. No, they're not.
All of this.
No, sir, everything started on February 3rd, 2024, when your tickets were issued. So anything. Let me answer. I'm trying to be patient, Mr. Cressell. Anything Judge Martin said at a hearing about those tickets after February 24th or February 3rd, 2024 would not affect the facts of what happened on February 3rd. Agreed?
But it affects what is going on with this court as far as the fact that
The only thing that's going on with this jury is deciding what facts took place on February 3rd and how they apply to the ordinances the township is trying to apply.
yeah, again, it's going on with that, but again, like I said, I'm not gonna subject myself to sitting here through something that I know.
Then get up and leave, Mr. Cressell. You're not under arrest. I've already explained your options. I've tried to be as clear as I can with your options.
Like I said, I will not participate in this. It was clear there's all sorts of stuff going on here that's great against me.
I understand you feel that way, but I've got a trial scheduled today. Something's going to happen. Once again, if you get lucky, they find you not guilty and you're done with this stuff.
Can I take advantage to figure out what I want to do with this?
Absolutely. Oh, one thing I want to make clear. The civil infractions don't go to the jury. You understand that? That's a formal hearing. That's just between us. You understand that? We'll deal with that after the trial if we have a trial today. The misdemeanors will be in front of the jury. You understand that? Okay, take a minute. Make it quick though. I hate to have the jury wait. Mr. Cressell?
Yes.
Mr. Bowditch is available. Doesn't cost you a thing just to get his opinion. All right. Go ahead. Go ahead. Wrong one. Hey, try to get him in here, would you?
We have our Monday, October 21st for our.
What I'm gonna try to do is convince him to do a bench trial, and I'll give him the whole freaking day. He can make all the other.
Oh, that's true, yes, so, because I was gonna say we can do the
Yeah.
afternoon on that one.
Yeah. So it'll be a special day.
Okay.
You know what Jeff's extension is in his office?
Security.
Hey, tell them they don't have to have a final decision. I just want to know if I can send the jury home.
Okay.
You're comment.
Hey. Hello. Thanks. That's fine. I got no problem giving you more time to talk, but if I'm letting the jury go, I just want to bring them in so I can talk to them and let them go. You can keep talking. You sure? All right. Bring the jury in.
So I go back here in a minute.
Yeah, keep talking. Keep talking. Hey, Jeff, come here. Mr. Cressell, I'm going to give him an idea to talk about with you.
Okay.
If you listen to Cressell, I'll give him a whole for bench trial. He can bring every argument he's got. All of it. We'll make her sit.
That's what I told him.
But I'm just not doing it with
I
him.
said, I wanted him to ask you politely to reserve his right to a bench trial.
Yeah. Yeah.
And all of his information, he's going to get together.
Just let him know that that's what I wanted you to know.
And
Go tell him
I'm
that.
not going to represent, him, but I'm going to help him.
All right. Go tell him that I made that suggestion. So Caitlin, I gave him an option that if he'll pay the $300 court costs, jury costs, I'll give him an adjourned date so he can perfect all his appeals that he says he wants to file, and we'll send the jury home.
But do you think he's gonna pay?
Oh,
He already owes us. Oh, he only owes us the money on these.
yeah, I think he'll pay. Is it hot in here? Or is it me?
No, it's just you, but.
Have a seat, folks. And Caitlin, you don't have to stay for this if you don't want to.
So were you last? Yeah, you got, you know, last a little? Right.
Are we missing one?
I still. Well, I didn't bring the last this moment. Yeah, but you guys don't have to hear it. What's? This guy. Well, I've seen it. Thanks. All right, how many of you got him? They just excited that you can think about being on a jury? One person. You aren't gonna make them. I'm sending you home. We're gonna pay you for being here, but I think it's $15, so that's part of it. But I just want to talk to you a little bit about what's going on. So, first of all, I want to thank you for being here, even the grumpy looking guy that don't really want to be here. But you showed up, okay, you showed up, you're doing your job. So the good news is, well, the good news is you get to go home. The good news too is that you served your jury duty for this year. You showed up, the fact that we're not putting your work is not on you, that's on us. Now, if the federal court sends you a notice, sure, fine, they don't care if you. Circuit court downtown, you know, if you get another notice from us, really will do for. Then you just say, hey, you know, I was there on September 23rd today, right? Okay. Very nice. Okay, so that's good to go. If any of you need a piece of paper that shows you're actually here, maybe an employer that wants to make sure you show up where you're supposed to. Are we doing that at the kiosk or downstairs?
Downstairs, that's right.
Okay, so then go down to the cashier, just say, I need a letter to show I was here for 30. Other than that, I'll take you out right now unless anybody's got any questions I can answer. Yes, ma'am.
Is there a possibility you will pay your son this week or?
No. Anybody else? All right, once again, sincerely, thank you for showing up today. I hope that this gave you all a free day, you can do something fun. Have a nice day. Sounds like a day. Sounds like a day. That's a man. Here's that. He's a problem with the cameras.
With who? The camera system. I got to text from someone in the audience. It was great.
It's the camera. It's the camera.
It must be.
Your suggestion. When you literally get, he's taking that suggestion. Yeah.
And Bowditch has already suggested, what? You don't do a jury trial, this judge will let you talk about anything you want to talk about. Which is what I just called Jeff up to the bench and say, look, I'll give him a whole day, he can make his traveling arguments. So we took Cheyenne's buddy Jessica Radcliffe up today. Or this weekend, because last year she told me she wanted to live out.
Nah. Thank you.
So Saturday
Now,
night,
what is open right now? Is it bow?
early antlers.
Early antlers?
Antlerless, so basically shooting does.
Oh, wow. She got it.
First year. She had a first year.
So, but it can be done by gun.
Yeah.
Anything just early, okay, because we were trying to figure that
Yeah,
out.
it's just to try and encourage people to shoot does and get them out of there.
So do you have to have a doe permit?
Hmm.
Okay.
Anybody can do that?
Well, you got a license.
Yeah.
But the cool thing Michigan did years ago when they actually changed the age, it used to be you had to be 12 years old to hunt, bow hunt, 14 to gun hunt. And then now there's no minimum age, basically. So they do a mentor license. So for example, Jessica can hunt 2 years in a row. With a mentor license, she doesn't even have to take hunter safety. It's kind of like, yeah, let's see if I like this. But she's got to have a licensed hunter with her at all times in the woods. Right? Which is a pretty good deal. You know, you got a buddy, it's like, hey, let's go on next week. Oh, I don't have a license. Or I don't have hunter safety. That's all right. Just go get a mentor's license. I'll take you and we'll go on. I'll have to sit with you.
So then for the 2 wheelers, if you're being mentored for 2 years, does that take the place of hunter safety?
No,
Or still take hunter safety?
before she can get her standalone license, she's going to have her hunter safety. Fine. Which nowadays is all. And then you got to find a field day somewhere where you actually show up any stand and stuff. It's pretty cool. All right.
Stand up. Please receive one. I can tell you.
We should probably have Caitlin.
Yeah, she's coming.
All right, back on the record with the People versus Cressell. All right, Mr. Cressell, I just want to put on the record the conversation that we had out in the hallway with Mr. Bowditch present. Outside of your hearing, by the way. That's for that. But I filled you in. So you've agreed, you're going to pay your $300 contempt charge. I put that in air quotes. I'm going to apply that towards the cost to pay this jury panel for being here today. Agreed? In exchange, we're going to pick a date, hopefully in the next 2 minutes. We're going to pick a date, put this back on our calendar down the road to give you plenty of chance to perfect your appeals, whatever you want to appeal. Agreed? Okay. All right, you can sit down. Okay. Now, but I have to say some other things. All right. Before I took the bench, I did a lot of court-appointed work, all right? So I know that a lot of times when a defense attorney is talking to their client, they've got to get over a mental hurdle because a lot of people in a situation where the court's provided the attorney, they think the attorney's not working for them, the attorney's working for the court. So I want to make sure you understand how this works. Mr. Bowditch, although we've worked together for years, he doesn't work for me. Really, he doesn't even work at my pleasure. I suppose if all 3 judges in this court told the Michigan Indigent Defense Council regional that he works for that we just don't want this guy in our courtroom anymore because he's just incompetent or whatever, they'd probably put him somewhere else. But other than something drastic like that, he's not here because I'm paying him and I've requested him. You understand that? Okay. His job, his client is MIDC. And I say his client because they pay him. But he's paid to represent folks in district court that don't have their own attorney. I just want to make sure you understand when he's giving you advice, he's not telling you what he thinks is best for me. He's telling you what he thinks is best for you. Okay? Now, the other thing, I'm assuming he brought my offer out to you. Listen, if you want to get into all those arguments that you've referenced today and the last time you were here, I'll give you that. I mean, I'll look at all the stuff you've got on the traveling argument, everything else, because what I told you earlier is I've got an open mind. Okay? I don't think in my heart of hearts you can convince me that your argument on traveling is a valid one, but I'll listen to everything you've got to tell me on that and every other issue. I mean, I'll give you an entire day set aside for a trial to do all that, but not with a jury. All right? So I want you to know that's an option. I'd like, and if you need to have some conversation with your family or Mr. Bowditch, I'd like a decision on that today, because when you walk out of here, I'd like to have a date on the calendar for either a bench trial or a jury trial. Okay? And I hope, based on my earlier conversation, you understand why I can be much more free and easy about what I let in when it's just me making the decisions than it is with a bunch of jurors. All right, Bowditch, go ahead.
Could we possibly adjourn this? Now, Mr. Cressell and I have had a conversation. I think we can streamline this case quite a bit. Could we set another motion date? It's nothing that's been covered. We covered new ground.
Okay.
This would be a simple motion with his understanding. It's yes, and then if we need to proceed to a bench trial, we would.
How far down the road?
Well, it depends on how long his discovery is going to take. If there's anything even possible to be retrieved, but I still do a month or so.
Probably a month is too tight.
Well, that's in the process. I've already appealed to the conference. I'm in the process.
Okay, hold on. I think so. October 21 is too tight, I think. October 21, I think is too tight. Time frame wise, you want to go into the next month?
We can, Your Honor, it's up to the courts.
I have no idea how that process is going to work, so I don't know.
With what the court's done today and asking more favors.
No, you're not asking a favor. We're just scheduling a date.
Do you do?
What is it?
That's a Monday before Tuesday.
Yeah, that'll be
We're
safe.
open that day.
That'll be safe.
If Caitlin is.
Do you have an opening on Monday, the 25th? You're not scheduled.
Of November.
Just for a motion. This is just a motion hearing. We're not going to take testimony. Okay.
As long as you're not, no, you don't have them that month, let's say.
So that'll work?
What's the date?
9 a.m., the 25th of November? It's the Monday before Thanksgiving. Nobody's got travel plans?
Motion date.
Okay. So I think what I'm hearing is you think that will either be dispositive or we'll set a trial date that day.
Yes, Your Honor, or we'll resolve.
Okay, all right. Okay. I didn't ask. Can you pay the $300 today? Okay. And I implore you, keep talking to him. Keep talking to him. All right. Anything else? All right. We're adjourned. Yeah, go ahead.
Officers are here and
Yep.
ready to testify.
Understood. And you can give them my apologies. Put it all on me. So your civil infractions, we're just kicking those down the road. Understood? Okay. Or I keep saying infractions. It's 2 misdemeanors, 1 civil infraction. All right. Okay, so everything's adjourned. I'll make a note in the file so the cashier knows what to do with your $300.
Mr. Bowditch, as your,
Not officially, I don't think.
let me just give you notice.
All right, this one's almost over. They do a little bit more paperwork, but I think it was 2018, Siwa Girl. I think it was 2018 when Judge Fleischer became a judge, because I know he's been elected. He did re-election once, and so waiting. ATX Alley had put 6 years.
Did
So
we set that at 8:30 or 9?
You said
so we'll get there. Thank you everybody for sticking around this long. It's a little over 2 hours. It's nothing compared to Kathy's 7 hours, but I'm still got my training wheels on, so I'm still trying to learn a little bit of that. Great topics in the chat. Thank you so much. There's links to Kathy's Discord, Court Vibes, and Tokyo Gaijin's Discord. There's links to them in the description. Make sure to go and check them out. They're really good Discords to be in. Kathy's, I think, is just the general Discord. I don't know if, I think whenever you just type in Discord, it goes directly to Kathy's. So make sure you go check it out. And in just a few hours, Court Vibes will be on with a new live for you. So y'all have a great night, and thank you to all the mods. Thank you for sticking it out, and all y'all have a great night.